Good morning and welcome to Real Divorce Talk San Diego. My name is Lynn Waldman. I am a therapist and divorce coach, and you can find my website at divorcecounseling.com. And I am happy to introduce my co-host with me this morning, Shawn Skillin, a family law attorney. Shawn's website is shawnskillinlaw.com, and Mark Hill, certified divorce financial analyst with Pacific Divorce Management. And Mark's website is pacdivorce.com. And today we are going to be talking to you guys about your divorce options, because we like to say that once you have decided to divorce, the next most important question is how. And we have a workshop called Divorce Options where we go into great depth about what are your choices, how can you make decisions, but we're going to give you guys an overview of that today. But first, let's hear a little bit about your practices, Shawn and Mark. Tell us, what kind of folks do you work with? Who are your clients that you typically see?
So I'm an attorney and I have a mediation and collaborative divorce practice. I have 4 locations around the county, so can meet wherever you are most comfortable and closest by. And I do all out-of-court settlements. So I do negotiated settlement cases, mediation cases, where I either act as the mediator or act as an advising and consulting attorney for a client who's mediating with somebody else. I also act as an attorney in collaborative divorce cases, and we're going to talk a little bit about the difference between mediation and collaborative cases as we go on this show. Mark?
Yes, I'm a certified financial planner, a certified divorce financial analyst. My practice is based around the financial aspects of divorce. I work in mediation and often as a co-mediator with attorneys. I also work in collaborative divorce as the collaborative neutral, and I do work with individual clients who are not going through a collaborative process, but I do not go to court any longer.
So I would like to remind everybody that we do have the Divorce Options Workshop. It is the first Saturday of the month. So this one coming up is June 1st at 9 a.m. And if you are interested in attending, the website is collaborativefamilylawsandiego.com, or you can call 858-472-4022. And so let's talk a little bit about what are people's options. When folks are considering divorce, what are some of the first things they should think about? What are the first steps? Because that's the question I often get. Client comes in and they've got so many things swirling around in their head, they don't know where to start. What do you guys suggest as first steps?
I always say it depends. If their biggest questions about legal issues, then I think they should start with their lawyer. If their biggest questions are about financial issues, then I think they should start with somebody like Mark. If they're still really emotional and everything's swirling around so fast and their head is spinning and they can't process any information at all, then I think they need to go to somebody like Lynn, who's a divorce coach and a therapist, so that they can kind of wrap their head around the divorce issues and settle down a little bit before they start making really important decisions. So my question, or my statement is always that it kind of depends. And so sometimes the best thing to do is, sometimes there's an emergency that needs to be taken care of right away, in which case then it's probably a lawyer, but it's better to kind of sit back and let things settle down a little bit if you can.
I agree with that. In fact, I'm going to turn this around and say the things you shouldn't do. Often what tends to happen is it becomes fear-driven. People become concerned, they're worried if they're the major breadwinner. Oh my gosh, how will I ever afford this? Will I ever be able to retire? If you perhaps have been the stay-at-home spouse caring for the children, your concern is, am I going to be living under an underpass? Will I be able to afford this? And that fear often drives people to get what they will describe as an aggressive attorney. Why? Because it'll protect them and take care of them. The challenge with that is, what kind of attorney do you think your spouse is going to get if you hire an aggressive attorney? you're going to get one that does exactly the same, and then you're off to the races.
And you know, I think people forget that because divorce is legal, it's financial, and it's also emotional, and that is the piece that so often gets lost, because you can't pick up a piece of paper and say, these are my emotions, but you can look at it and say, you know, this is my paycheck.
Right.
And the emotions just, you know, get people completely sidetracked. And I ask clients, do you want to be right or do you want to be effective?
Mm-hmm.
Do you want to be making a decision from an emotional standpoint or with the facts in front of you?
Well, I think the other question is, how much money do you want to spend on your divorce?
Mm-hmm.
Some people don't have a lot of money to spend. They don't have too many options. Other people have all the money in the world. How much of it do you want to spend on attorneys and specialists and experts testifying and discovery and, you know, all of these things? For the people that are in between, you know, how much money you spend on your divorce becomes a really important question. And so each of the options that we're going to talk about today have different price points. And so you want to be careful about which option you pick, not only by how much it costs and how much of your money you'll have left when it's over, but the kind of emotional atmosphere that it creates. And I think one of the questions all three of us always like to ask people, especially if they have kids, is, you know, 20 years from now, if you're at a family party and you overhear your children talking to their cousins or someone about the divorce, what kind of story do you want them to be telling? Do you want to be telling about how horrible it was and how much you fought and how you couldn't do soccer anymore because there wasn't any money left? Or you know, your college savings got spent on the divorce? Or do you want them to say that, you know, your parents stayed friends and they were able to co-parent and they did their best to keep you out of the middle of it and it was not really that disruptive to your life? So you have to kind of give some thought to how you want this process to look down the road, because somebody said the other day, I can't remember where I heard this or saw this or read this, but somebody said, somebody can give you a cactus, it doesn't mean you have to sit on it. So divorce is kind of cactusy.
It's cactusy.
You have to decide, you know, just how much of those thorns you want to poke at or sit on, and it is a really emotional time. It's very upsetting. It's very anxiety provoking in many different areas. Are you going to be okay? Is there going to be enough money? Are the kids going to be okay? Will you ever get married again? Will you live alone for the rest of your life? All of those kind of things, but it doesn't have to spiral out of control.
So I'd like to remind our viewers, we would love any questions that you have, so please write in with questions and we'll do the best we can to answer them right now live. And so for now, let's talk about one of the first options, which is do-it-yourself. The do-it-yourself divorce.
I call it the college divorce,
Yes.
Lynn. It's, you know, you take the CDs and the books and I'll take the dog, you know, and it's simple and there's not a lot it's a short relationship, you don't have a lot of assets, you don't have children. That may be appropriate for do-it-yourself. You can go down to the courts, the facilitators will help you with the paperwork, and if you're in agreement about how you're going to divide things, very, very straightforward. But the challenge comes when you have children, when you have assets, where you've commingled a life financially. It takes a lot of examination to determine how that can be separated and set you both up for success post-divorce. So do-it-yourself is certainly an option. An increasing number of people do it. We have all seen judges get frustrated with people trying to do divorce by themselves because they really don't care, and Shawn, you should address this, that the people don't know what they're doing in their court. So my advice is that before you jump down any path, though, that you step back and take an inventory. And so with do-it-yourself, is it simple? Is it straightforward? Is it short-term? Are there no kids to worry about?
Yeah, so the do-it-yourself divorce, there's some books out there. Nolo Press puts out a book that's pretty good. And the Family Law Facilitator Office is at every family courthouse in the state of California. It's required by state law that those services be offered. So whatever county you're in, you can Google your county court. In San Diego, I just always put in SD courts and it comes up. And you can click on that button, click on the Family Law tab on the top banner, and it will take you to some self-help services. You can now sign up for their workshops and make appointments online. So their workshops are kind of lengthy. You're required to go and sit through how to kind of fill out the forms and things like that. Only so much help is available to you. There are court forms. Court forms are available online at your local county court website as well, especially in San Diego. And there's packets that you can download. You have to figure out each individual form. And the courthouse even has some kind of fill-in-the-blank agreements that you can use. They're fine, like Mark said, for the college-type divorce. If you have retirements and things that need to be divided, they're not sufficient. If you own businesses and things like that, also not sufficient. But if you can do it through the facilitator's office at your local courthouse. And so in San Diego, there's one in South Bay, there's one in El Cajon, there's one downtown at the new courthouse at 1100 Union Street, and in North County. So that's one of your options. It's, of course, inexpensive. You have to be able to work with your spouse to be able to get things done, because there's papers that both of you have to sign. And if you end up not being able to come to an agreement, then you will eventually end up in front of a judge, and you will have your own little trial. And their job is not, the court's job is not to teach you how to do a trial. They won't help you along. They do expect you to understand what evidence you need to present and how you need to present it. And sometimes people say, oh, well, the judge won't let anything bad happen. And the judge doesn't want anything bad to happen, but they can only make decisions based on the information that you provide them and the information you're allowed to provide them. So you do need to be prepared. So if you end up having to go to court in a do-it-yourself, I would at least go consult with an attorney so you know how to be prepared.
And so what about litigation? What are some of the pros and cons of litigation? And I want to remind our viewers, please write in. We would love questions. We are talking about the different options for how you divorce. And so litigation.
So litigation is what most people think of when they think about a divorce. You get a lawyer, I get a lawyer, we kind of hash it out in court. So it's the most expensive way to get divorced because you're each paying your own attorney. There's formal discovery that has to be done, which is, you know, getting all the bank statements, the mortgage statements, the car loan statements, the credit card statements, the business statements, the ledgers for the business, the tax returns, all those things. And so when it's done in a litigation case, that's done formally through certain formal requests, and it gets more expensive. If you have pensions that need to be valued, businesses that need to be valued, real estate that needs to be valued, then experts are hired, sometimes different experts by each side. Sometimes you might agree on one. And so it gets cumbersome, it gets time consuming. And you know, litigation is kind of a I want to win so you kind of lose kind of thing, and both sides are trying to win. So it's adversarial, and if you have kids, I always think it's the least productive way to get divorced because it's kind of hard to shake hands when it's all over and then go back to the Little League game together and smile. So, but that is the traditional way that most people think of getting divorced. So I don't know, Mark, do you want to add to what the bad things are about litigation?
I think it's so time consuming for people and they don't think about this, and you lose control of your time. If the court says you're going to be here on June the 3rd, you will be there on June the 3rd, or you will have lawyers representing you on June the 3rd. You don't get to say that's a bad day for me, I'm gone that week. You show up. Also, the delays involved are pretty bad, and you can talk more to this, Shawn, than I can at this point, but I've heard that it's months and months just to get in front of a judge, and some of these cases are taking 2 and 3 years to get through. You know?
Yeah, I've got one right now where the clients called me this week, and they've been in litigation for 2.5 years. And they just went to their mandatory settlement conference. This is kind of your last ditch chance to settle it at a court with an attorney or a retired judge who volunteers to kind of help try and settle the case, and they were unable to. So they're set up for 2 weeks of trial coming up, you know, over the course of the next 3 months, and they came to me and said, do you think we can mediate this, because we're not getting anywhere with our lawyers and they want more money and blah blah blah. So, you know, it gets very time consuming. It does take a long time, so it'll be like 3 years by the time they finish their case. And you do kind of get on a schedule once you go down the litigation route. The court will say, this is when you have to have your discovery finished. This is where you have to designate your witnesses. This is when you have to do that. So whether you're ready to make those decisions or not, you're kind of forced along this court timeline. So in the other processes, you have more control. The good things about litigation are that it will get done. I mean, it will get settled. The court will force you forward. And if you can't agree with your soon-to-be ex-spouse on how to handle the house or the kids or the bank accounts or the business or the retirements, the court will tell you how you're going to handle it. So it will get done eventually. And the courts, Mark's completely right. The courts are very backed up and very behind, so it doesn't happen quickly. But it will get done. There will be orders made and decisions will be made.
So you can compel, basically,
Yeah.
in the court environment. And if you've got someone that's dragging their feet that perhaps doesn't want the divorce, and so they're just trying to string it out in the hope that the other party will come to their senses and come back into the marriage, the court process may be what you need to get things going. So we do appreciate that. But I would echo what you've already heard, which is basically it's the least productive way to do it. It's the most stressful way to do it. And the end result often tends to exacerbate the issues that made you get a divorce in the first place. I mean, I found that when people come in to see me initially, they don't usually hate the spouse. They're not usually wanting to hurt them or to get the most they can from them. They will always tell me they want what's fair. Of course, the challenge is, you know, fairness is like beauty. It's very much in the eye of the beholder. But at the same time, unless you can get into a process that allows you to communicate, the results will probably not be what you hope you're going to come out with. And so unless you've got somebody on the other side who's really not cooperating at all and won't come into any kind of alternative dispute resolution process, the courts are the way to go.
And you're right, there are so many delays with it, and I've heard recently that the court now is setting trials for February, that they're so backed up. And so it is such a lengthy process.
And expensive.
Yes.
I was involved with a case last year where it was a nice estate, but it wasn't huge. It was in the $5 to $10 million range. So a very nice marital estate, but not hundreds of millions of dollars, as we sometimes see. And the result, they were going to have a trial in April. It got continued to October. I called up in October or in like August and said, what's going on? I need to look at this case again. I've forgotten all the details if we're going to trial. And got a call back from the client, and the client's response was, oh, I settled it.
Oh, wow.
I said, why? I said, we had a very good case. It was, I won't go into details, but I thought we had a very good argument. He said, I was told that it was going to be a 10-day trial, and my lawyer wanted a $250,000 retainer to try the case. His response was, I figured I could give it to him or give it to her, and if I gave it to her, I might get some brownie points. So I did, but I didn't. So, but I mean, people don't, what tends to happen in litigation is people walk into a lawyer and they say, I want a $10,000 retainer. So you write the check and you walk out of there going, well, that's not bad. I don't mind paying $10,000 for the divorce. But then 3-4 months later, the retainer is gone and nothing's occurred that you can see. They have been working, they've been perhaps putting the documents together, and then there's more money. So the challenge with litigation is that the costs tend to escalate as we approach court if we cannot settle it. Whereas in alternative dispute resolution, it's the opposite. The costs are up front because you're gathering all the data, you're spending the money to put your resources in place to help through the divorce, and it looks expensive, but as you get going, the costs come down because you've got all the data has been accumulated in an environment where we're not fighting about it.
So if clients decide they want to avoid litigation, they don't want to leave all the decision making to the courts, they want to have more say-so over the outcome and their kids and parenting plans, and they decide to do mediation, what are some of the struggles there? What are some of the benefits? What could clients expect from mediation?
Well, I'd say first let's talk about what mediation is. So mediation is a consensual alternative way of resolving your divorce or any dispute. So it means they're both there voluntarily. They both agree to participate. And it shouldn't be happening in a vacuum. So they should be coming together and they should be sharing information. And you're still going to be gathering a lot of the same information like bank statements, mortgage statements, credit card statements, car loan statements, all those kinds of things. But you do it voluntarily between the two of you without all the formalities. And in mediation, a lot of times you might do it yourself. If it's complicated, then you might have somebody like Mark working on the mediation case and helping you get all that stuff together and generate some reports and ideas for you. So it's a voluntary way of getting together with a neutral third party who helps facilitate a conversation, provides you with information on the basics of what your rights are under the law in California when you're getting divorced, and does the paperwork for you. So they usually file the petition and the summons and all of that stuff with the court, and then either if they're a mediating attorney, they'll write up your agreement at the end and get that through the court as well. But Mark does some mediations, and so then when you're in mediation with Mark, then you usually have your own attorneys helping you with the paperwork. So mediation is a voluntary process where you're both working together with a neutral third party who helps facilitate the conversation so that you can reach with agreement. What else would you add to that, Mark?
I would add that basically we're neutral and we are purely facilitators. We cannot give advice, but we can give information. Now that's a very fine line you have to dance around. And so the challenge with mediation can be when there's an unlevel playing field, when one party knows a lot more about the finances or the children than the other party does, and we're trying to resolve issues around those. That can be challenging because the one person who has less knowledge may not feel like they're in a position to negotiate. So it works best when you have both parties who are comfortable in each other's presence and also have a pretty even knowledge or can be brought up to speed so they have an even understanding of what's going on with the finances and the children in the marriage.
And another difficulty could be that one person might be a better negotiator than the other. Just maybe not have those skills, or kind of like what you're saying, fill at a loss with the information.
Yeah.
And that makes it difficult.
And mediation still works in some of those circumstances if you have a mediator who's sensitive to what's going on and knows how to balance that out. Like wife isn't up to date on all of the financial information. It's really common in a marriage that either the one spouse or the other is what we call the managing partner and manages all the finances. Well, they have now a duty. In fact, they're kind of at a disadvantage because they have a duty to bring the other person up to speed. And the law requires that the other person see all this financial information, have all that financial information before they enter into an agreement. But if that person has it all and doesn't understand it, then the mediator should be telling that person that they need to go out and work with somebody else like Mark to bring them up to speed, or to get a consulting attorney to bring them up to speed and help them understand the finances and what might be a reasonable agreement. So a mediation should feel balanced to you. You should feel like both parties kind of have an equal say, and that the mediator is making sure that both parties are prepared and capable of negotiating, or they should be withdrawing from the mediation. Now, just because you're in mediation doesn't mean that you can't have somebody like Lynn working with you outside the mediation as a coach, someone like Mark working with you either as an individual, kind of in your court, or with both parties as a neutral in the mediation. So you're not without resources. I always like my clients to have consulting or advising attorneys on the side. If nothing else, to review the agreement at the end, make sure I didn't mess it up. So those things are possible.
What about the costs? Do-it-yourself clearly is going to be inexpensive most often. Litigation could be terribly expensive depending on the fight and how long it goes. But what about mediation? What can you say what the average cost is?
A successful mediation is certainly probably the most inexpensive way to do this. I won't say that it's necessarily the cheapest, because a failed mediation that goes to litigation can end up being very expensive. So there are certainly risks associated with any approach you take in divorce, and there's no guarantee of a successful outcome. But generally, it is the most inexpensive way to get divorced, in my experience.
Even if you have other professionals or consulting attorneys, it's still less expensive than litigation would be.
Yeah, so I had a mediation I did, and it went on for several years, so it didn't go very quickly, but there was a very complicated case, a large estate, complicated business situation. And so there was a business evaluation that was done. There were pension valuations that were done. So experts were brought in, but they agreed on who they were going to be, and they accepted their reports. And so if that case had gone to trial, and that, I haven't added it up, but let's say that was a $20,000 mediation, that could have easily been a $250,000 divorce, or much, much more. So mediation usually is your least expensive way to go, other than do it yourself. The bad things about mediation, or the possible negative things about mediation, is the mediator can't compel anybody to do anything. So if one person's not coming in with the financial stuff, the mediator doesn't get to say, like a judge, that, hey, you will have it by this date, or there's going to be some kind of punishment, you know, like a sanction in terms of money, or an issue sanction saying you're not going to be able to argue that point in the future. So the mediator can't compel people to do things. And that sometimes can be difficult if you have a reluctant party that just doesn't really want to actively participate for whatever reason.
I want to say something cautionary about this, though. There are people that hold themselves out as mediators there, and you want to be very careful about who you choose in this role. If any of the people listening to this broadcast want to be a mediator, the only thing you have to do is hang out a shingle and say, I'm a mediator. There's no requirements, either federal or state, that you have to do. Now, all of us have had training in mediation and have worked in the field for years, but there are individuals out there holding themselves out as divorce mediators that we see the cases after they mess up, basically. They come to us after they've gone through challenges. So be very careful about who you utilize.
And if you're mediating with someone who's not, if you're a mediator with someone who's not an attorney, then you need to have a consulting attorney.
Yeah.
What are some good questions for folks to ask if they're interviewing or considering a possible mediator? Like, what are 2 or 3 of your top questions you would say they should ask?
So I think they want to know what kind of professional they are. Are they an attorney? If they're an attorney, do they practice family law? Are they a mental health professional? Are they a financial? Did they used to be a hairdresser that became a mediator? I mean, one of my former divorce clients bought a divorce mediation business. He was a business guy. He'd been through a divorce, but that was his background. So you need to know what kind of background they have. You want to know how they mediate. What kind of process do they use? Are they an information-giving mediator, or do they think you should mediate in a vacuum and it's kind of like, well, what do you want to do? Well, what do you want to do? And okay, and no information. I wouldn't be comfortable in that kind of mediation in a divorce case, because there's so many things that are going on that you need to have information about. You need to know, are they going to meet with both of you in the same room? Are they going to have you in separate rooms and they're going to go back and forth? Those are the kind of things that you want to ask. You want to ask for a copy of their fee agreement up front. Different mediators charge in different ways. Some people take a retainer up front and then bill you by the hour. Some people have pay-as-you-go and charge you flat fees for doing certain paperwork. Some people have charged a flat fee and then you get so many hours for that and so many services, and after that it's an hourly fee. So you want to understand all of those kind of things. What else would you ask, Mark?
Well, I think the important thing, if it's not an attorney, is what is the product going to be? You know, what are you going to get in terms of what I'd prepare is a memorandum of understanding that will list all of the agreements we've made and what we've decided to do with everything, and that then they can take to an attorney who can draw up an agreement. I always require 2 attorneys if I'm not at the table with an attorney.
So
to be in place.
transparency is important. And
Essential, yeah.
And you know, and also maybe, you know, how many mediations have they done?
Oh, I would want to know, is this their 3rd mediation, their 30th, or their 300th mediation?
Yeah.
So I think that's a very good question to ask.
So the next possible way you could consider getting divorced is through the collaborative process. What are pros and cons? And maybe tell us, for our viewers, what is collaborative? How does it work? What could clients expect from a collaborative team?
Collaborative is a team-based, I mean, I just for simplicity's sake, it's mediation with resources at the table. We've talked a lot about mediation and how you could have an outside financial person, you'd have your attorneys on the side. They may or may not come to the table during the mediation. And so when that happens and you have a lot of difficult issues or a lot of contention, mediation tends to be slow because we're constantly sending them back to get other information, and that can take time, and not everyone does their homework assignments, so sometimes we get delays around that. With collaborative, it's a team-based approach where each side has their own attorney. Each side will have a mental health professional working with them, not doing therapy, but essentially helping with communications. And if there are children, there'll be a neutral voice for the kids, a child specialist who will bring information to the table of what the kids are experiencing and what their needs are. In fact, it's the only model that has a role for a voice for the children in it. It appears expensive from the outset because you are paying for more professionals, but it also brings those resources to the table so it can make us very efficient.
I like to think of it as wraparound services for the family. And even though each client has an attorney that could give them advice, as opposed to a mediation where that one neutral person wouldn't, the attorney is really helping their client think about, what does mom need? What does dad need? What does the other spouse need to get through this? So I love it because there's so much transparency and it's family focused.
I mean, really the whole team is focused on what are this family's goals. In fact, in the very beginning, they work with their coaches, like Lynn, to come up with a mission statement so that everybody can stay focused on coming up with the best plan. So there's not a lot of hide the ball going on. Everybody's very open about what the finances are, what the problems are, where the sticking points are, and everybody's basically just working together to try and help this couple brainstorm the best outcomes. So Lynn, you work as a divorce coach in our collaborative divorces. Can you explain what your role is as a coach?
So my role as a coach is to help the client stay calm and to understand the process. And one of the tools that I love, as you mentioned, Shawn, is the mission statement, because the other coach and I will get together with our clients and look at what matters to you. How do you want to get through this divorce? We're going to write it down. These are a reflection of your values, what you see as your end goals. And it's a really great tool because it keeps both clients on track through the process so that the emotions aren't derailing any agreements or negotiations. So my role is to assist with communication, managing emotions, learning how to tolerate the distress of a very difficult situation, and thinking about the kids, if there are children. What are the children's needs? We'll work with the child specialist in coming up with a parenting plan. And our focus is going to be, how can we get this family through this process that's going to be good for both of them, as best as it can be, actually. Maybe good isn't the right word, but as best as it can be through a difficult process.
Yeah. So sometimes clients they always have their own attorney, but sometimes they have their own coach, and sometimes the coach works with both parties. When you're working with both parties, how is that different from when you're just working with one?
When I work with both parties, I feel like it's so important for both of them to feel heard and understood on an emotional level. I want to be able to have that resonance of, I get where you're coming from. It's validation. And it's not necessarily that I agree with you, but I hear you and I hear your concerns. And we also need to hear the other side. We need to hear both clients. So I want them both to feel like they have a voice. It's not unusual that in a relationship there's a power differential. And so I kind of want to change that dynamic. So one of the things I love to do is give clients a protocol, and we'll rehearse it and we'll practice it when we meet together for how can you say what you need to say in a way that you're going to be heard. So you don't have to yell, shout, shut down. So we're changing how they communicate, and I'm giving them actual tools that they can take with them, not only through the divorce, but into the world for communicating and being heard and feeling that their voice matters.
So Mark, the financial person in a collaborative case is almost always there. We don't necessarily need a child specialist if there aren't kids. But what is your role in a collaborative team process?
Well, my role is very much upfront initially. In fact, most of the work will be done with me because I need to gather all the financial data, put together a report that says this is the pie. We cannot start dividing a pie till we agree what the pie looks like. So let's gather all the data, agree that these are all the assets, these are all the debts that we have, this is the income, the family income we generate, these are where our expenses look. So I'm gathering all that data from both parties and putting it in what is hopefully a concise report. I always say if I get over 15 or 20 pages, I've failed with this thing. So I try to make it very readable, very understandable, and it will lay out all the assets, all the debts. It'll lay out a table that shows this are the expenses that husband anticipates post-divorce, this is what wife anticipates, and this is what the kids are going to cost. And once we've got that data, we can start to have a conversation about what do we want to do with all of this. So it's a process where if I can get cooperation from the parties, and sometimes it takes a while to get all the data. Sometimes you have somebody who's not quite so keen to get divorced as the other party. But once we've gathered that data, then we have essentially what is the menu that we have to get through. And then we can start to have meetings, and then we hold our meetings to start to deal with substantive issues. But my role is neutral. I'm the individual that both parties have to feel comfortable, that I have no axe to grind in this, that I'm basically there to provide them with information. Sometimes I will work with one party more than the other because they need education. They need to be brought up to speed. They haven't been the one running the money. And so how can we get them to the point? You said something very interesting earlier, Shawn. The person with all the financial information is at a disadvantage. And that's very hard to hear for some folks. You know, what do you mean I'm at a disadvantage? I know all this stuff and I'm holding it close to my chest because that gives me power. Well, no, sir, I'm afraid it doesn't, because your wife wouldn't know a good deal if it walked up and bit her on her leg, would she? That's an old expression my father used to use. But, you know, think about it. If you are scared and you don't understand this stuff and somebody else is already taking care of it, any deal they're offering to you must be good for them, right? Because otherwise they wouldn't be offering it because they understand all this stuff.
And I think that's a worry I've heard clients say is that in the collaborative model is that their attorney's giving them advice, it's going to be against me. But really, in the collaborative model...
Yeah, Shawn, talk a little bit about how different it is to be a collaborative attorney than the normal litigation attorney.
Okay. In a litigated case, if I represent Lynn and Mark has another attorney, then Lynn and I are working together to get the best deal possible for Lynn. Mark be damned,
Yeah,
right?
well,
sorry, dude.
That's quite okay. I feel exactly the same way under these circumstances.
And Mark's attorney's working the
Yeah.
same way to try to get him the best deal, you know, regardless of what Lynn and I think. But in a collaborative case, the paradigm shifts, and really, although I may be Lynn's attorney and we're working together and I'm educating her about the law and discussing her various options, we're not saying Mark be damned. We're saying, how is this family going to look when we're done? These two have come in and devised a mission statement, which usually says something like, we want the kids to be okay, we want to both have enough money to have a nice place to live, we want to have enough money to have a comfortable retirement. And so our job as attorneys is to keep that mission statement in mind and help them devise a solution that makes that come true. So it's not a I'm out to get you and you're out to get me type thing. It's a working together thing to try and make the best personalized divorce outcome for this particular family. So it's a very different role. There's no formal discovery. We voluntarily have our clients produce whatever information that Mark needs to do. So it's a very different thing. Now, it's important to understand that we all sign, and the clients sign, a collaborative stipulation that has a disqualification clause in it. And that's one of the risks of collaborative, kind of just like you could spend a lot of money mediating and be unsuccessful and then have to go to court anyway. If one of the parties drops out of collaborative process, both parties have to get new lawyers and start over. And usually the coaches can't be involved and the financial can't be involved, and so they're going out and starting from scratch. Fortunately, most of these cases are successful in either mediation or collaborative. I also just wanted to add that Mark, or whoever the financial person is, in addition to their role being collecting all the finances, is they kind of become the keeper of the process. They kind of become the person who, since they are neutral, schedules the meetings and make sure that we all stay on track and things like that. So they have an additional role.
Also facilitate the meetings.
And facilitate the
because
meetings,
that's important, because you and I have been in many settlement conferences in normal adversarial divorce, and it's a very different experience than sitting in a collaborative meeting.
Yes.
The reality is that if you have a desire for a good relationship with your spouse post-divorce, and not everybody does. Some people just want, I want to be divorced and I never want to talk to him again. You know, I've heard that. But if you have children, you will be involved with them way beyond the age of majority. There will be graduations. If you're lucky, there'll be marriages. If you're really lucky, there'll be grandchildren. And you want to be able to be in the same room when the kids graduate, when they celebrate things associated with their children. And you don't want to be in a situation of a client of mine, a wealth management client from many years ago, who kept coming to our events with her significant other, and she was in her late 30s, early 40s, and this was a couple who've been together forever. And I said, at one point, I blindly asked her, are you ever going to marry Bill? You know, I mean, you guys have been together forever. She said, if I could have a wedding that both my mother and father would attend, I would have done it years ago. She said, but if I have a wedding and I invite my mother, my father won't come, and they divorced 25 years ago.
Wow.
Yeah.
Wow. So I want to remind everybody, we have a divorce options workshop coming up June 1st from 9 to noon in Carmel Valley. Please call 858-472-4022 for more information. And our next Facebook Live show is right here, June 20th at 10 a.m. And we look forward to seeing you then. Thank you.
Bye.
Bye.
Bye-bye. Boy, that